I was looking for some of that bourbon. Oh, go ahead. You're live.
Oh, yeah, then we're live. Hello, everyone. Welcome to Uncivil Law with my friend Nate the lawyer, who I'm not attempting to disrespect by forgetting to send him the link so that he can join the stream. How's everything going, Nate?
Everything's going fine. I've been trying to catch up on stuff. I had the tough thing about being a solo practitioner is that when you get cases, it takes up so much of your time that it's taking me away from what I like to do, which is YouTube. But unfortunately, YouTube right now just doesn't pay all the bills, so I still have to take cases, which is still sad, but it's okay. I'll be all right.
Yeah, well, hopefully that means at least that you're, for bringing cases, bringing in money, so that's good, so you can pay the bills.
Oh yeah. Well, the good thing about
I just got my tax statement from YouTube.
Oh, is it good? Is it a good thing?
Well, I don't know. They said how much money they paid me last year, so now I have to tell the IRS how much money they paid me, and now I have to pay them some money because I didn't have any withholding. So the IRS is going to want some of that.
Well, it all depends. You bought a new camera. You take all those business expenses.
Yeah, I'm going to have to pay the IRS some money.
Well, I thought I would, but because most of my fees come to me untaxed. But I bought a new computer. I bought the new camera, the Shure mic, like all this stuff I buy.
Yeah, I can write off the camera, and I can write off the stuff from Fiverr, and I can write off probably all the super chats that I made under my account as advertising. Mm-hmm. So we'll see what we can do.
I don't know. You're going to do super chats for advertising.
Those super chats I made from my account. Sure, why not?
Well, this is not financial advice, just for everybody out there. So yeah. Let's make sure people understand this is not financial advice.
Yeah.
But yeah.
It's a business expense.
Oh yeah, I think so. I have a lot of business expenses. Like everything, I'm writing everything off. This shirt is a business expense. So.
There you go. if we can get the Jack Daniels in there, can I get bourbon as a business expense? Can I do that?
If you need it for the job, right?
Yes.
I don't know. I took a trip to Vegas. Not last year. It was the year before last. About shit. My trip to Vegas. I was trying to, but I don't think it's gonna work. I have a couple of trips to Atlantic City where I filmed. That may work, but we'll see. Nate's lamp would be a good business expense. I hope.
There you go.
I've had the lamp for so long. Depreciation of value.
Maybe I can write off some of the utilities. I could rent off part of the room that I'm using for the YouTube because I'm doing this in my living room / kitchen. So I could write off pretty much my entire apartment as a business property. So yay.
Yeah, no, but you should do it. Small business expenses. That's what all this is a business. This YouTube stuff is a business. So
I'll ask TurboTax what I can do and see how that goes.
I forget last year I had. Last year I'm thinking I could have about $10,000 business expenses with computers, camera, trips, and all that. I can
write off the hat as a business expense. That's a good idea.
The hat, because your hat's about $800, right? So
yeah, it was an expensive hat, so I can write off the hat as a business expense. That sounds good. Yeah, it's costume. Yeah.
There you go.
There you go. No, I like these plans. These are all good plans. I look forward to arguing with the IRS about some of these things in the future. This will be good.
This is good lawyering right now. This is good lawyering.
If I get in trouble with the IRS, will you represent me?
No, absolutely not. Okay. Because I'm not an IRS attorney. If I was a tax attorney, I would. You try to get me to practice law without a license in some of these places. You scare me.
Can I write off all the completely unsolicited ads I've been doing for Toddy Beauty and Halo Beauty?
Ooh. Well, they would be able to write them. I don't know. Are you getting paid for them? If possible.
No, it's just an expense for no particular reason.
Oh my God. What about this the Halo Beauty thing? Because it seems like that's I listened into it wasn't a hearing, it was a status conference, and it seems that it was just like the judge. One thing I like about the judge was kind of like, let's just cut the bullshit. You know what I'm saying? It's just like, let's cut the bullshit. It's over. But I think the judge is more sympathetic to KJ's side than the Saltsy side. She seemed to me to take more issue with Saltsy than she did with Brown. What did you think?
The judge? Yeah, well, I agree with that. And some people were asking me in my chat why, and I sort of said that I think it was just a roll of the dice that day. It's like the dungeon master deciding which side of the table is going to get the breath weapon from the dragon or something. Just like roll a d4 or something and see if it comes up even or odd. It's like, why is Salt's getting slapped around? I don't know, because he was convenient at the moment. As my working theory. So
Well, don't forget, there could be a couple of mistakes. Number one, Brown is from that jurisdiction.
That could be a thing.
So he may have been in front of that judge before. She may know him, so she may say, this may not just be something out of character for him. So that's why I'm thinking she could have been. But again, who knows? Because Brown has a very extensive history, it looks like. So, but what did you think about that whole status conference anyway? At the end of the day?
I thought the admonitions from the judge were pretty much on point. I liked it. Like, stop making these aspersions against the. I particularly like the judge getting really snarky with the we can do this trial anytime you want basically comments, because it's like, you guys need to quit this from social media, the insinuations against each other. And if you can't control yourself, if you can't prevent yourself from using social media, then what we can do is we can roll that trial right up, so you won't have to control yourself for very long. And then once it's over, you can go back to slapping each other on Twitter. But you're not going to do it in my court. I thought that was a really sassy moment from the judge. It's like, how'd you like to have the trial tomorrow? So that way you can go back to your Twitter war. I was like, that's pretty good. That's pretty good.
Well, it's kind of like, but if I'm Brown, I'm like, well, we got to kind of figure out this motion to dismiss first.
I'm just saying, I'm available. I know you haven't had any discovery of any kind, and you have no witnesses presented. But if it will help you, we could do this thing tomorrow. So it's like, I know you're completely unprepared. It was just a nice little snark.
It was
comment.
good. Yeah,
I laughed pretty hard.
It was good.
Yeah.
Oh, at the end of the day, though, this is still a motion to dismiss.
It was theoretically.
What the hell? When are we ever going to talk about
I don't know.
When are they even going to hear the motion to dismiss on?
I don't know.
It's like, what are we doing here? That's my thing to hear from yesterday, is that I'm going to schedule the motion to dismiss for X day, right? The hearing for that.
I was a little bit surprised. I was surprised the judge didn't lead with that. The what are we even doing here question.
And for those of you who don't know, just to give a quick recap. In a civil trial, when you start a civil trial, the plaintiff, in this case, Toddy Westbrook, writes a complaint. And that complaint, she says, Katie Joy Paulson, you did a bad thing. I'm making allegations against you. You're a bad person and did bad things and owe me money. Now, in the usual course of business, the defendant will answer and deny those allegations. I didn't do anything bad. She's crazy. Let's the jury find that out, right? But KJ, instead of doing that, there's a second option. And that option is to say, okay, if everything Toddy's saying is true, then she still doesn't have a case, right? Statute of limitations ran out. There's no jurisdiction, something, right? There's some legal issue, the reason why that her case can't go forward.
Her theory of the law sucks.
Yes, it's something like that, right? She's quoted the wrong law. It's something, right? Something. And those are called 12B motions, right? 12B6, 12B1, 12B, you have a whole bunch of them, right? So generally the standard is whatever Toddy says, we got to accept it as true, right? Because now the reason is, now you have to think about this as a logical progression. And the reason why we have to take it as true, because KJ officially hasn't denied any of them, right? KJ hasn't answered. She hasn't denied anything. So the only person who's made allegations,
she kind of has, because she has an affidavit out there, their declaration.
But again, the standard for the motion to dismiss is what? So
everything
that's why
Toddy says is true.
So for her to deny stuff at this stage makes no sense, especially when you're arguing jurisdiction. Because if you start denying allegations, then you waive jurisdiction. So that's why usually people are careful not to start denying stuff, because they say, hold on, if everything she's saying is true,
right,
you don't have a case. So that's why it's very confusing to us who are legal professionals, why you would see the defendant make any type of statements or, it just doesn't make any sense. Go ahead, Kirk. I'm sorry.
No, I'm just saying there's definitely a non-zero chance that the judge is going to say, because of something Brown did along the way, he's waived the jurisdiction issue, which means that all the expense of, I don't even know how much we've spent at this point on just this thing, will have been completely wasted for both sides. How much have we spent between the two sides at this point? $100,000
minimum at a minimum. Well,
it will all vanish into nothing. That was a productive use of our time. Just light $100,000 on fire.
Well, let's not forget Salty, for instance. the videos, the recordings, the 50 filings, right? It's insane. So yeah, you're talking about probably $100,000 in just hours. So I just don't understand. As a legal professional, I just don't understand how, number one, the attorneys will bill up their clients this way, right? This could be a 4-pager, right? This is how are we billing up the clients for all this back and forth? And number two, it seems to be irrelevant for the motion at hand, because if the judge says if the judge is to rule that there is no jurisdiction, then everything that's filed goes up in smoke, right? It's all unnecessary. So I don't understand it.
We could have just filed the answer, saved ourselves $100,000 plus, and 3 months and like 40 different filings.
Yeah. But don't forget,
and at this point, I don't even know what the practical reason is. I was thinking about this. What is the practical reason to fight jurisdiction at this point? Because normally it's an issue of geographic convenience. Yes. But at this point, with the courts meeting virtually, does it really matter if it's heard in Washington or heard in Minnesota for either party? So like, if I'm Katie, do I really care if this is heard in Washington at this point?
At this point, because you're so much in it and this judge is so into it, possibly. But don't forget, jurisdiction is a constitutional issue, though. It's a constitutional due process issue. So
but I don't have to care about it. I can waive it.
Yeah, but she's not waiving. She's got a motion.
But that's what I'm saying in the first. That's why I'm saying in the first instance. It's like if Katie comes to me with this case, and I'm thinking about what I'm going to do I even file the jurisdiction-based issue? Because I can waive personal jurisdiction. It's like, why not just waive it? Because
well, I think two things. Number one, two reasons why you do this. Number one, you get a friend. It's probably going to be friendlier for you in Minnesota than it is going to be in Washington. Even though everything is still virtual, you still got to file. You still got to have your attorney over there. Blah blah blah. The second thing is that you're getting out of the case cheaply and quickly, right? So usually a motion to dismiss, you file two things. You file the motion to dismiss and then reply to whatever they reply to, right? So you can get out quickly. This is extreme, but I would have filed the motion to dismiss, right? If you get it dismissed, then the plaintiff has spent all that money filing the case, filing fees and everything. I just responded and we're out, and then they got to do it again. So that's the reason why I think it was good. But now at this point in time, I think you're right. I think it's a zero.
Yeah, it's complete. It's a complete loss.
Yeah, I think it's a complete loss at this point, because now you've already spent the money that you were trying to save by filing a motion to dismiss to get it thrown out. So
yeah, so say Katie wins. Say Katie wins on this motion to dismiss, which is still possible. And then Toddy winds up refiling. So now Katie is short $50,000 or whatever in expenses that she doesn't have to litigate to achieve not much. It's $50,000 that she's taking away from the principal arguments that could have been better spent somewhere else. Unless Katie has a source of money that I don't know about.
I don't know. Unless maybe the hope is that she won't file again in Minnesota. It's funny. Somebody said in the chat, Emily D. Baker said that Washington laws are actually better for KJ in Washington and Minnesota. But the one thing that, and maybe Emily said this in her stream, I'm not sure. It's not just because the case will be filed in Minnesota. They can still use Washington law. Right. And when you see this is that, and sometimes in contracts, you'll see a choice of law provision where the contract will say our jurisdiction's in New York, but the law we're going to be using is Florida law or something like that. Yeah. And in this case, if the defamation or the claims happened in Washington, for instance, then even if you're in Minnesota, what you would do is you would apply Washington. The Minnesota courts would actually apply Washington law. Since this is a federal case for diversity, it's as simple as that.
Right. So yeah, just to basically repeat what you just said to make sure that people got the point. What place you're hearing it in doesn't necessarily mean which law you're applying. So we could be in Washington applying Minnesota law and Minnesota applying Washington law. You can have an issue, and that's principally going to be determined by the determination about where the torts were committed, because that's the relative issue. So if the tort was committed in Washington, we apply Washington law. If Minnesota, we'll apply Minnesota. So the torts were probably committed in Washington is the most logical conclusion. That doesn't necessarily mean there's personal jurisdiction for other reasons, but they can have a fight about that in Minnesota about which law is going to apply. There's whole choice of law issues that you can go through.
Yeah.
Courts can analyze. It's not a huge deal, or it shouldn't be. And then again, even then, I'm not 100% sure how much difference it really makes, because I haven't got down into the minutia on these issues, because the standards for like defamation are pretty similar. Now, there are some differences to be sure, but those differences really matter in the end? I don't know.
Well, I think it all depends if you're talking about, because don't forget, since you're in Minnesota now, there's a procedural difference in the way, procedures may happen in Washington versus Minnesota. But even though we're still, you change federal districts, because now you're going from the 12th Circuit to a different circuit. So there will be differences, choice of venue and so forth. And it may be easier for Katie to find an attorney more familiar, locally. And it'll be a little tougher for the plaintiffs who are coming from Washington and California to now litigate a case, because now they got to find.
I could fake it. I could fake it.
Yeah, and I think Katie will have a, well, if she gets it, and that's the problem, and that's the thing where I think the opportunity missed here with the motion to dismiss by not arguing and I'm fumbling my words, by not arguing the defamation piece to this case and the motion to dismiss. If you get a dismiss for a 12B6 for defamation, then the case is over, right? You can't bring it in Minnesota. The case is over. You lose on the merits. But so by doing that, and if Katie does win on the jurisdiction, she doesn't win the case. They're just saying, well, now move it to this other jurisdiction. But if she would have won on the defamation on a 12B6, where you failed to state a claim, then she wins the case and you can't file it again anywhere. That's why me and Kurt was so crazed that why you didn't argue the defamation, because the defamation wins you the case on a motion before there's any trial, before any evidence is heard. She could have won the case on a motion to dismiss on a 12B6, and she and Brown for some reason blew it. I don't know why.
Yeah. So what the motion to dismiss really probably should have looked like is, basically for the sake of argument, for this purpose, we concede that all these videos are right. We concede that these are what they say, right? Because we're conceding the facts, because we have to. And then we just come back with a legal response. It's like, okay, here's why, as a matter of law, we still win, even though we did said all those things. And here's what that looks like. Toddy's a public figure. Without a crystal ball is a public figure. We can even get to James as a public figure. We can at least argue it. I'm not sure it's a slam dunk by any means. But he's appeared in videos.
Well, hold on. I did a little bit more back checking. I looked into James a little bit more. And to be honest with you, he's a public figure. He's more of a public figure than I think you or me. I think if someone was to sue, if I was to be sued or judged for defamation, yeah, I think he's a huge public figure. I went through Toddy's videos, and not only is he in like a lot of those videos, right? He's their business partner. He's the partner with Swanson, and he's got solo videos up there, right? With 700,000 views, 1 million views. Where he is doing it, a male's perspective, this perspective. And if the standard for public figure is someone out there seeking public attention, right, for someone seeking notoriety, James fits that bill. He was seeking notoriety, seeking this. He was on these videos, doing this press, So I think he's not only a public figure. I think because he's such a public figure, he is done. Hold on, let me pull up her channel, because
I certainly haven't looked in the background to contest you on the factual. So fair enough.
I can pull it up, because people maybe because they'll only be doing those Toddy's YouTube channel. But when you look at it and just type in James, she has so many and his solo videos and all that stuff, and it just convinced me he's a public figure. If he's not, then I'm not. And I think even with not only with James, but who else? Would you consider yourself a public figure? I'd ask you that first.
I don't know. I mean, I don't know if I'm quite in that territory or not. I'm making a lot of videos. I'm doing a lot to inject myself into the public space. So maybe. But even then, it would be a very limited purpose, because I don't know, because I don't really discuss my personal life that much. It's a legal opinion analysis. So I'm not sure if I'm a public figure or not.
Well, are you seeking public? Are you seeking? Because don't forget that the whole goal of a public figure is that if you're seeking public attention, then you are. If you're seeking attention from the public, then you got to take the good with the bad. And I think your channel and my channel even fits within that. Now, it all, obviously scale and things that matter. But yeah. I think if you're just talking about that aspect, we're seeking public attention, then for that, we would be a public figure.
Yeah, well, I think it's arguable, but let's just continue through the analysis. So we can argue that the three entities are public figure. If they are public figures, then you have to show actual malice. What actual malice means is you have to show knowing that you knew it was false, or reckless disregard the truth. To prove reckless disregard the truth, you have to show quite a lot. It takes quite a lot of effort. And basically, Toddy's own civil harassment claim kind of defeats them on that element from the defamation claim, because the civil harassment claim is, look at all the stuff that you did in terms of like digging up our lives, but you feed that right back in the defamation claim. You're right, we did do a lot of stuff. That's how we show we're not negligent. Look at how much stuff we did. If somehow we came to the wrong fault, even if we said wrong facts, somehow if we came to wrong facts, it's like, it's not for one of trying or not for one of looking. So how can we possibly have reckless disregard? And then you go even to the next standard of like negligence. So if they're not public figures, you go to, if they're private figures, then you have to show at least negligence. And the argument there is exactly the same. How can we possibly be negligent when we've done so much stuff? You can't even make negligence, let alone actual malice, would be my argument. And I think it's a pretty good argument. Yeah. And then you got some ideas of some underlying truth of some stuff, because there was, I'll put the thing on screen in a second when I'm finished my thought. But there was statements that were made that seemed to have some underlying validity to them. For example, that James was found in default judgment, which was later reversed, but it did exist, and that he was found in default judgment to be in fraud relating to a business that he was involved in. And there's also other things that show some other things that, so there's like some underlying truth here, and the rest of it is just a protected opinion anyway. So I'm like, on the defamation thing, it's like, I can make some pretty colorable arguments. So we'll put this on stream so that people can see what we're looking at here. Show us what a Toddy looks like. I've never seen her channel before, so this will be a first.
9 million subscribers.
Now I'm going to see what a Toddy video looks like. This will be good.
Well, no, we're just going to look at the videos that James is in. So this is testing masking, right? So her and James are in this video. Then boyfriend TAG, so they're in this video. Then man's favorite, so this is his solo video on her channel, 710,000 views. Then their wedding, James' favorite products, husband does makeup, PR unboxing. Here's another unboxing. They're preparing for the wake up. Here they're doing the peel offs. You can see this guy is all over this channel. Right?
That's a lot. I mean, that's not just incidental contact. It's not like he's just passing through the shot or something when she's making videos. He's being prominently pictured and figured with respect to makeup products.
Look at all
which
this.
Is also part of their core business. So yeah, the public figure stuff for James is looking better and better with every passing moment here.
But every video, I would just add up all these views. 1.9 million views pre-unboxing. Here's another 1.8 million views. Both of them together. They're doing many videos together on this channel. Look at this. 1.1.
Whose channel is it anyway? Right.
This is Toddy's. But don't forget, they're.
Are you sure
partners.
It's not James's?
they are business partners, right? They are business partners.
Yeah.
So this whole, this thing, I think James is not only going to be found, he's going to be a public figure for sure. Like, you just don't, you're not in, think about this. My channel alone has 1.4 million views for the whole channel, for the life of the channel. He's in like 4 videos that beats that alone. And some of the videos by himself, beats that alone. So James is a public figure. I understand people hate KJP, right? I understand that. But just in the legal aspect, I don't think James can get around and, being a public figure. It just is what it is. You know what I'm saying?
They're allowed to hate her. They don't have to like her. That's a matter of opinion. And I try to remain as detached as I can over here and just try to analyze the law. And that's why I got into so much trouble with my early videos too, because I was like basically saying in my early videos, you go look at my chat in the comments, people were mad at me, like, you're a secret Katie supporter, you're a stan for Katie. I'm like, no, I'm just trying to analyze the law, and I think this is the best legal opinion. And people are like, you don't know how evil she is, you don't know what she's done. I'm like, you're right, and I don't care. You can't comment on this unless you look at the videos. I'm like, I'm pretty sure I can comment on it without looking at the videos, because I can just rely on what's on the pleadings, because I can look at what they tell me they're and just rely from there. So I'm like, yeah, I'm pretty good.
But now
even Katie says we don't understand the law, Nate. So
yeah, we don't understand.
We can't get any love from anybody.
Yeah, we don't understand it. But now, for the Katie haters, we've talked about the positives for Katie's side, right? I think Katie should win this case. But now let's talk about the negatives. The 4 cease and desist.
It's closer. I think I could argue either side. I think this might actually make a fun mock trial, because I think it's one of those things where I think I could argue either side of it and win.
Yeah, I think I think the deck would be stacked a little bit against KJ, because against KJ, I think, well, especially with the precedent, the only thing that really convinced me KJ is going to win on the merits is the precedent. If you go to all those cases with commentary channels and YouTube, you can't. I don't think you can overcome that, because the precedent is so well set. If you're a commentary channel, if you're doing this type of videos, you're protected as a commentary channel, and more reasonable people wouldn't take what you're saying to be seriously. Tucker Carlson, Rachel Maddow, the National Enquirer. I think you're under a bench. But I think the thing that's saving Toddy's case, right, which is not giving me the 100% to 0, which has got me about 60-40, is that I think Toddy's best arguments are, I think she loses on all of them are public figures. I think they lose on that. But I think they have, like the Dominion case. If people look at Dominion versus Sidney Powell and Dominion versus Rudy Giuliani, the voting systems that just sued them for defamation, they sent them cease and desist. And they're using the cease and desist to overcome actual malice. In other words, saying, you knew these things were lies, we told you they were lies, and you continue to say them. And I think in this case, by having four cease and desist sent to her and saying that these things were lies, and if they can show that she said those things after that, then I think you can probably overcome the actual malice a little bit. What do you think about that?
Let me think about it for a second. So the idea is that we're going to use the cease and desist notices itself as a way to get, it depends how the cease and desist notices are written, but assuming they're written the right way, then the idea is that we're conveying actual knowledge. But even then, I'm not so sure, because it would be if I wrote you a letter and said, here's the facts, that doesn't mean that's true. That means what I want the facts to be, or what I'm presenting them to be. So I don't know that necessarily puts you on actual knowledge of falsity. It might let you know that we have a disagreement, but it doesn't necessarily let you know what is true. So I'm not so sure. Well, and the people do go to this 4 cease and desist notice, like the fact that there's 4 of them is somehow extra meaningful, and I don't quite buy it, because whether you send 1 or you send 100 of them, if they're crap, they're all crap. So I don't really get the idea that because they're 4, if it was 1, that'd be one thing. But there's 4 of them she ignored. I'm like, that's not really doing that much for me.
No, I agree. I think for the amount is the issue. I think the people who make the arguments for the cease and desist and for the letters are against, what's his name? What's the frog guy? The frog's a gay guy. I'm gonna send you 5. I'm gonna send you 5 and cease and desist by tomorrow, just for the hell. No. I'm talking about, who's the guy from InfoWars? Alex Jones for the Sandy Hook thing, right? They sent him the letters, they sent him all the evidence, this actually happened, and he said it again, right? And they used that. They were like, no, the reason why we can show actual malice, because we showed him the truth, we showed him all the evidence. Rudy Giuliani and Sidney Powell, they showed them the evidence. We weren't, we're from Toronto, we're not from Venezuela. They showed them the evidence, and in their pleadings they said the reason why we can beat actual malice is because we sent them the evidence on why these things were wrong, and they still said them anyway. In other words, you don't have to. I agree with you in 2 points. Number one, the quality of the cease and desist. They definitely that's going to matter in this trial. And the second thing is the amount is not going to matter. If we sent you 100, it's not going to matter. But is that enough to overcome actual malice to show that you knew that what you were saying is false? That depends on the lawyering. But I think that's the best argument that they have to overcome, because if they don't have that argument, then I think you lose on actual malice, because Katie, because on one end you're saying Katie was doing all this research, right? All this research, and on the back end you're saying that now she has to have actual malice. You can't have that. You can't have it both ways.
It seems like you can't really have that cake and eat it too. That is a problem.
Yeah,
that is a problem. But
now
with
have actual malice.
Alex Jones, the reason he knew it was actually false is because any sane, reasonable observer would know it's false in the first place. It's like this whole thing was one big, massive false flag with
false flag.
I'm like, okay, no sane person could think that. So that's how I know it was actually false, because it doesn't make any sense.
That's true. Well, again, they went through the process though. They went through educated him, and he said it again. And they hit him with the lawsuit. So it's American law. It's very tough. But I honestly think the CDs are going to be their big play if they can get past this motion to dismiss.
All right.
So
here's how I try to make this work for Toddy's side. First of all, I'd write the complaint a little bit differently, because I'd probably move defamation down in the causes of action. I'd probably reorder it. I'd probably put something like I'd probably put negligent infliction of emotional distress as the top cause of action. And then maybe put IIED as the second cause of action, and get to civil harassment. I'll probably do NIED, civil harassment, IIED, and then defamation as the fourth cause of action, because I want to emphasize the stronger cause of action. And defamation is a little bit weaker because of these issues that we've been raising. So I want to show that the negligent inflicted emotional distress by, for example, when Katie insinuated / outright said / whatever with respect to James pulling his mother off of life support, possibly to get life insurance money, or whatever the more specific statement was. So I want to really emphasize that and push that up. And I want to, if I have any therapy that I've gone with, make allegations at least that this has caused me to undergo therapy and loss of whatever, that I can make really hammer home that an IAD claim. Then go to IID, or maybe go to civil harassment because of you've been doing all this for all this time. You've been harassing us. Then go to IID, which I know won't work because IID never works. And then maybe finish off with defamation. And then I want to rewrite the defamation cause of action to just kind of, and they did this to some degree, but I'd want to try to amp it a little bit more. But just the sheer number of them, and try to show that because I'm trying to lean into how many there are, because if I can win on one, maybe I can make this thing work. So just try to really sink into, here are like 50 different videos, and really pull. They didn't really pull enough quotes from each of them. They didn't really, to my mind, make a good job of showing why each of the videos, what they had to say. They just basically said, here not really, but here's 50 videos, and they're all bad. They didn't really go into enough to say why they're bad, or what they said that was wrong, or what the false facts were. So try to pulling out more, and try to write it that way, and see how that works. So I think reframing it and restructuring it would have helped.
Interesting.
So now I'm giving notes to Salts too. So how about that?
I agree and I disagree. I agree in the sense where you start with your strongest arguments. I definitely agree with that. And this is for anybody who's out there, law school students or whatever. You definitely want to start with your strongest argument, right? You want to put your strongest argument forward, because they tell you to start strong, end strong, right? Start with a strong argument, end with your strongest. Well, usually it all depends, because I had one professor said start with your strongest and end with a strong argument, but some said do it in reverse. Start with a strong argument, but end with your strongest, because you want, after the judge pulls off the page, you want them to say, okay, wow, that's a good argument. But in regards to I honestly think Salty did a hell of a job with writing that pleading, because
he did a fine job.
That pleading, the complaint was written for two things, and I think Salty, this is something that I think Salty is a master at. He's a master at. He wrote that for not only the judge and the court, but he was able to read it. He was able to write it legally sufficient enough where it did everything he needed to do in court, but also write it in which it was able to give us the tea, right? That was written for both us as laymen to read and say, oh my God, this is what's going on. But for a judge to read and say, this is legally sufficient for defamation. And I think that was an amazing job. And it was to win and that's what happens now. He is winning the court of public opinion, because let's not forget, we haven't even heard the answer, right? We're judging. Everybody who's judging this case is only judging this case, hearing the allegations. Just like one side saying you did a bad thing, and we haven't heard from the other side yet, right?
Yeah.
So that's kind of where we're at, and I think Salty did a very good job in putting it forward that way. But I also think what you're saying is true. When I looked through the complaint again and looked at all the allegations and looked at all the statements, it just, it's a loser. I think the case is a loser. Based on what I know about defamation, I think his case is a loser, but I think it's a loser if somebody was punching back in the right way. I don't think Brown punched back in the right way.
No.
So I think that's what's giving him options. But if Brown would have put all his chips on the table with this motion to dismiss, I don't think it would have a shot.
I've said that before. I've said that before in a perfectly argued case. I think KJ has it better. And I wasn't trying to criticize Saltz by saying, here's some ideas, because I had the benefit of looking back in hindsight and Monday morning quarterbacking and be like, here's some things that, maybe would make this even stronger as maybe an editor. And I'm not sure that if I was doing this in the first instance as an editor, I'd be able to spot it. But now it's like, now it's developed, I can see some weaknesses, like, okay. And if you get to refile, because this all gets dismissed for jurisdiction, one of the nice things there is that you can restructure it because you get to start all over. So you can make improvements if you want to. But Saltz's pleading was perfectly professional. He's been perfectly, well, I won't go quite that far. I was about to say perfectly professional the whole time. It's like, no, I'm gonna have to take that back in about 5 seconds. But he's right. He was the one who started the personal war between him and Brown, because he's the one who dealt with the bad faith, which was unnecessary. And he's been poking the bear a little bit. Now Brown's also been doing some poking the bear, but Saltz kind of got this party started as far as I can tell. So, and also the insinuations and accusations are a little bit much. And I think the judge was right to point out that the Katie declaration from the UK was containing these allegations that she would have no basis to have an opinion on. Brown or Saltz was saying, well, she believes it to be true, and the judge is basically saying, but she has no basis to form that opinion. So why are you even including it? Just because she believes it? It's like there's no basis to believe it. It's just random musings.
Because Saltz is, and I think the judge got it right. Saltz is trying the case on Twitter, and I think the judge is like, it's time to try the case in the courtroom. Let's stop the Twitter. No, but that's what Saltz is doing. The Lorianne thing, irrelevant for a motion to dismiss. Why? Because everything that the plaintiff's saying is true, and so why put the Lorianne thing in? Because we already. And I got in such an argument with KJ Hayter the other day about this. They were asking me about the Lorianne declaration. I said the Lorianne declaration is irrelevant. And they were like, why? Why is it irrelevant? No, it's saying this, it's saying this. I said, well, it's irrelevant because we're at a motion to dismiss. Everything that Toddy said is true. And she said that she got people from Washington giving her super chats, right? Yeah. So we believe it's true. So now why do you need a witness to tell us that something is true that we already are assuming is true for the purposes of this motion? That's why it's irrelevant. It might have been relevant if we have an answer and we're going to a discovery phase or going into a trial phase, but on the motion to dismiss phase, you it's like you have somebody asserting something is true that we already are taking is true. It's unnecessary at this particular stage. It was unnecessary for her to do. It's unnecessary for Salty to charge, but it was necessary to win the court of public opinion. KJ's friend flipped, and all of us ate it up. Oh my God, Lorianne flipped. But at the end of the day, it was irrelevant to the motion at hand. What do you think? Yeah,
it is pretty irrelevant. The only reason it's relevant at all is if the judge really wants to go into buying this agency theory that Lorianne qualifies as an agent for Katie, which I don't personally buy, but that's the only reason that matters at all. Yeah. Otherwise, it doesn't matter. So, I mean, if we're talking about things that don't matter, Nate, I mean, my God, we even had something that's mattered in quite a long time in this case.
No.
We've had precipice upon precipice upon precipice. It's like, I haven't said the word precipice this much in my life, Nate. Why?
And I got to give it to the other side, too. I think KJ's declarations are a mistake. I think that's a huge mistake.
They're a mistake.
I think it's a huge mistake because I would never have my client testify when it's unnecessary, right? You got 4 declarations there, and each one of those declarations can be chopped up. So even if we do go to trial, now I have impeachment material, right? You said this, is that true? You said this, is that true? I found you this. There's a mistake here. There's a mistake here. When I finally get you on the stand, or when I finally get you into a deposition, you just giving me four declarations that are material for me to impeach you and make you look like a liar. I do not think I think that was a huge mistake as an attorney.
It was a huge mistake.
Especially as a motion to dismiss stage. So I think both sides have made critical errors in trying to
and Brown made
prosecute his case.
Brown made that mistake right off the bat because he attached that to his original motion to dismiss.
It was unnecessary.
Yeah, so he screwed up the motion to dismiss by never asking to dismiss the defamation when we've been pointing out how we have some really excellent things we could be saying here, and he screwed up because he attached a declaration from Katie Joy. But Katie Joy can only testify or offer facts. I mean, she can't offer law. She can only offer facts. But why is she offering facts? It's like, she's like, that's not true. Here's what's true. It's like, wait a second. You want me to consider what you say is true? So you want me to start adjudicating the facts? It's like, isn't that jurisdiction? So I don't
jurisdiction.
That was a baffling mistake. I do not understand why in the motion to dismiss it included a declaration from Katie Joy. That is a baffling choice to me.
Here's a good question. Lorianne's declaration wasn't necessary after KJ's statement that she didn't have business in Washington. That's from Brenda Lee.
That was completely over. It was the wrong line of argument too.
But let me.
Brown finally got to where I thought it should be. It's just like, yeah, she has business there. It just doesn't matter.
Yes, but let me try to help this person understand. Yes, right. Lorianne's declaration was unnecessary, right? Even after KJ said, you know why? Because KJ's was unnecessary. Because we're at the spit where no matter what KJ said, KJ could say everything Toddy's saying is a lie, right? She could declare everything Toddy's saying is a lie. But what's the standard for a motion to dismiss? Whatever the plaintiff's saying is true. So that's what makes it necessary. Yeah. So even if KJ did, so that's why KJ's putting in her declaration was irrelevant, and then Lorianne rebutting KJ's rebutting what KJ put is also irrelevant because everything the plaintiff's saying is true. That's the standard that we're trying to judge this under. I hope people understand that.
It's exactly Katie Joy saying everything that Toddy says is a lie, and me as a judge saying, no, it's not. Everything she says is true. I did not get this. Everything she says is true.
No, if I'm the judge, I'm saying
confusing.
If I'm the judge, I'm saying, so are you answering the complaint? Are you waiving jurisdiction?
I wouldn't blame you for going down that road. I wouldn't blame the judge for going down that road. I guess I'm a little bit more merciful on this issue when it comes to waiver of personal jurisdiction. I guess I'm a little bit more merciful. But if the judge smacks, there's definitely enough fodder if the judge wants to say Brown has waived personal jurisdiction, in which case $120,000 between the two sides poofs, disappears into a pile of smoke. It's like, well, that was good. We just lit $100,000 on fire. That's great.
to argue personal jurisdiction.
To argue an issue that basically didn't matter in the end. I'm not even sure it mattered from the first instance, as I was saying earlier, because I'm not sure how much it really mattered for this case to be heard in Washington. It's like we can do the depositions. It would be cheaper, even if I have to fly you out there. Even if first of all, we could probably do it online. Yeah, but even if you really want me to come out there and do it in the conference room, it would be way cheaper for me, the attorney, and you to get on a plane, fly out there, stay at budget hotel, right? Go to the conference room, do the deposition, fly back. That'd be way cheaper. So why not just do it that way?
This. Oh, you have a couple of super chats. It looks like you.
Yeah, well, I'm having a wonderfully productive conversation with you. So sometimes when I have a guest on, obviously my ability to answer super chats is a little bit diminished because I want to pay attention to the person I'm having a chat with. So hopefully that you can respect that and understand that decision. But let me
hope the people in the super chat. Yeah.
Maria M says, does KJ tweet and videos about her case hurt her? Yes, for the love of God, yes. Every time she opens her mouth, it hurts her case. Every attorney on the face of the planet would tell their client to shut up. Please stop talking. Because every time you open your mouth, it can only hurt you. I heard because I didn't see it, because I don't watch these streams. But I heard Katie Joy in her infinite wisdom on a recent live stream showed emails between herself and her attorney.
That's waiving. That's waiving attorney-client privilege. If you show me,
yes, it would be, Nate. That would be what we qualify as a problem.
But what did it say?
I don't know. I was like, yeah, you showed the emails between you and your attorney to the public. So the attorney-client privilege as to those emails just went poof. The attorney-client privilege potentially relating to what talking about was subject, depending on how anal the court wants to be, kind of went poof. So like, yeah, attorney-client privilege just kind of vanished in some degree. So if I'm the attorney, I want to, there's not enough bourbon in my world for this. It's like my client just completely, not only did they violate attorney-client privilege, which I suppose is their privilege to waive, but more to the point, they harm my relationship with them because I'm trying to talk to them and they're harming me and making me look like an idiot too. So I'm a very grumpy lawyer if this is happening. That's what, how I feel about it.
So she actually did that? She showed attorney.
Apparently it was a mistake. She didn't know her desktop was visible. Well, be a lot more careful now.
Oh my God, maybe, that's horrible. That's horrible.
Maybe don't stream with the emails on your screen so that you don't have that problem.
Maybe that's a gift.
If the attorney-client privilege, that's great news.
I thought Brown's motion to dismiss was a gift. Like, I'm like, he didn't even use the word defamation, but this is a gift if you're giving up.
I don't know what Brown's relationship is here. I'd love to see this retention agreement between Brown and Katie. See if you can get Katie to give us a copy of the retention agreement. She apparently has no concerns for her privacy anyway. So maybe we can analyze that on stream. That'd be good.
Yeah, just so everybody knows, just in case anybody's asking, one of the for attorney-client privilege, the privilege, the number one, the plaintiff or the client, it's the privilege is the client's to waive, right? We as attorneys can't waive the privilege, right? When a client tells us something, we have to keep it secret, but the client can waive the privilege, and there are exceptions to the privilege. So if you have a third party who hears a communication, then it's not a privileged communication because you got a third party there. So that's what happens with these emails. When she produced these emails in a third party, which is everybody who watches her channel saw those emails, then those communications are now deemed not protected under attorney-client privilege. So that's a huge mistake, especially if there's something incriminating in them. You're done. It's ridiculous. But
oh yeah, no, that'd be good. That'd be the really good emails. I totally defamed them. I knew I was defaming them. It was my hope and purpose to defame them. But yeah, we only get that kind of thing from our FBI T hour. That's the FBI T hour. It was my goal and purpose to commit the riot. I was hoping to accomplish this. Let me tell you about me and my friends and how we organized and decided to storm the battlements together with the social media and the confessions to the FBI. I'm enjoying FBI T so much, and it will never ever end.
There's so many confessions. Oh, excuse me. I don't know why they're just. It seems like those Capitol rioters are just so dumb. They're just like, yeah, we did it. It's like, what? Why are we even having trials? Just I don't know. It's crazy.
It's like some of them were doing the tour thing. There were a couple people taking photos with the statues, like the statue room and stuff like that, and taking their feet up on the desk, getting some nice little selfies. I mean, the total amount of video and images that the FBI has is like, where do we even begin with this? That's the fun times.
It's facial. You saw they had the guy who won 2 gold medals. One thing that you really see is that some of these people are just mentally frail.
He was wearing his team Olympic jacket.
Not he won 2 gold medals with Michael Phelps, and come to find out, he had fallen on tough times. He was like living in his car. This guy was just like just really falling on tough times. But it's a 6'6" Olympic champion. It's rated. That's like, what? Like, you didn't think people would recognize you? But they did.
Yeah, but he was wearing his team Olympic jacket at the riot. The jacket that he got from being on the Olympic team. I mean, that's kind of identifiable, Nate. It's like with the patches and everything. This is an Olympic jacket. Not a whole lot of people have it. Kind of narrows down the suspect pool. From sheet dragging gives me 499. Is it possible that Brown is creating all these declarations because KJ is insisting? If so, Brown should just say no, because Katie can't insist. And we'll discuss this in a second. Do some clients treat their lawyers like garbage? Well, that much is true for sure. But the classic relationship between the attorney and the client is the client sets the goals to be accomplished. The lawyer sets the means to accomplish them. So you come to me as the client and you're like, here's what I want to have happen. I want to get this permit. I want to get recovery for damage to my whatever. I'd like to not go to jail very much. These are the things that you set. You set the goals. I'm like, great. And then I set the means to go there. So what you not tell me is you don't tell me what witnesses to call. You don't tell me what documents to file. You don't tell me what affidavits or declarations to include. You don't get to insist on anything other than here is the goal. After that, it's like, great. Now sit quietly in the corner while I do those things. So if Brown is doing things because Katie's insisting on it, then Brown should be a lot stricter about those boundaries. Because like what my answer would be, no, I'm not doing those things. If you have a problem with that, you can get a different attorney, but I'm not doing it.
It's simply the same thing that happened with Trump just recently with his attorneys, right? The attorneys said, hey, we don't want to argue, for the impeachment. We're going to argue the unconstitutionality of the impeachment, and he wanted to argue that he actually won the election. Yeah. So but as their agents, they said, well, we're only going to argue this, and he's let them go. He fired them because he wanted them to argue something different. And it's funny because the new attorneys argued just because they didn't even argue that he won the election. But that's
he wasn't able to find anyone who was willing to really argue the complete stupid.
Well, because you'd risk your license at that point. You're risking your license.
Yeah, it wouldn't help. That's for sure. I'm not sure if it would risk your license or not, but either way, you look like an idiot.
So, but that's what I think. And I don't want to mislead people in a sense, because I agree with everything you said is 100% true. But in reality, though, like when I have clients, a lot of times the clients, I'll say I want to call this witness. You negotiate, you talk to your clients and let them know what your strategy is. But at the end of the day, it's your license that I got to call this client because and your license is on the line about perjury and all that stuff. So Kurt is 100% right. The means in getting the tactics they're using is all on you and your license. So you have to be very careful. But I do think that in this instance, I think Brown could be, hey, let's do this. Let's, maybe. And I want to tell my story. I want to say this. And I'm thinking Brown may not be thinking that way about, how this is going to hurt the case in the long run. Right. Because for him, all these declarations are this. That's money in the belt. That's money in the pocket. Right. Every declaration, every email, everything. That's every 6 minutes.
Well, that's definitely a possibility here. Brown is just doing all these things because Katie says so, because Brown knows it just jacks up the fee. It's like, sure, I'll file these declarations and these things because it's just more legal time I'm going to be spending. So that's a reasonable choice the lawyer can make. Like, it's like, yeah, you want to file this declaration, you want to file this, you want to do this, you want to do that. It's like, great. It's just more money for me, and it's as long as it's not frivolous, right? Yeah. So as long as it's not frivolous, I can do that. And nothing Brown has done has been frivolous. Maybe not wise, or maybe not the greatest thing to be completely consistent with the legal philosophy of what we're doing for, but he's within the bounds if he wants to do that. And I only hope he got some of the money up front, because I don't know where he's getting this money from, where she's getting money from, and I hope he's getting at least. It's like, where's my $50,000? Hopefully he got a big ass retainer to start with or something.
But don't forget, this status conference is going to cost, because don't forget the status conference is going to cost you a couple of $1,000s, right? You got number one, you get an hour to prepare for it, right? An hour afterwards to decompress. Yeah. So you get 2 hours worth, and if you're talking about at $300 an hour, so he's already made 2 hours worth of time. Then you have the status conference, which was about an hour, so you got that, and then you got preparation for the status conference. So these hearings and conferences, you're killing it, right? You're killing it on time. So, and that's one thing about an attorney, especially when you're a paid attorney. One of the goals too is to try to get the best outcome for the client at the cheapest price, right? You're trying to get the best outcome for the client at the cheapest price, because that also helps your client and it helps your reputation, right? This guy, is expensive, but they help keep the cost down. And nothing that I'm seeing here in this case is even remotely trying to keep costs down, right? Especially Salty's got a blank check. He's arguing on Twitter, on the clock. And with Brown, I'm thinking the same thing. So I don't know what they're doing. I don't know. These people all have deep pockets, because at the end of the day, somebody has to maybe sit down and say, hey, listen, let's evaluate what the cost benefit analysis for these 50 filings. It almost makes no sense, because we had a motion to dismiss. This could have honestly been done in 5 filings. Right, 5 filings, complaint, motion to dismiss, reply to the motion to dismiss, and then reply to that, and that's it. Right, that's more or less it. That's 4 actually. So 4 filings.
Yeah, it could have been done in 4.
We got 50.
Yeah, we got 50, which is more than 4.
It's like what, 12 times more? 40,
Yeah.
12 times more than 4.
Yeah.
So this, look at Tucker Carlson's case. The whole case had 40 filings, and that ended.
Yeah,
So
no, I was pointing that out on my stream the other day. It's like the entire case with Tucker Carlson, the entire defamation case, was done in like 40 or 42 filings or something like that.
Yeah.
And when I was looking at it, like, we're already up to 45 and we're close to the end. It's like by this time in the Tucker Carlson case, we were done.
Yeah.
And it was like, Don is nowhere in sight. And because the best possible scenario for Katie at this point is the judge grants the motion to dismiss for lack of jurisdiction, because they can't dismiss the case completely because they never moved to dismiss the defamation. So they can't move to the most the judge could theoretically do is dismiss every cause of action except defamation, because they never moved to dismiss the defamation. Right.
Well, if you dismiss the jurisdiction, you lose the defamation anyway. Jurisdiction catches everything.
But so the best possible scenarios for Katie would be: 1, dismissing for one of personal jurisdiction, or 2, dismissing every cause of action other than defamation as not sustainable by law. That's the best cause of action, and then that's the best result. And then we're still going. It's like, why?
You know what? That'd be an insane thing. Let's say if you keep defamation, but you dismiss all the ancillary causes of action, and then have to go to discovery for the defamation, because it just shows you now.
And the defamation is going to take forever on discovery. It's going to take forever,
unless you can get a motion for summary judgment out there, and hopefully the judge hears it before defamation. But I don't think that'll happen. You'll have to go to the defamation, because it's be second bite at the apple. That's why I don't see how I still don't see why they didn't plead the defamation in the motion to dismiss. It just doesn't make any sense. You literally, all right. So people can understand what my thought process here. And law, when you're executing one of these cases or prosecuting one of these cases, you get certain bites at the apple, right? You get chances to end the case. The motion to dismiss is one chance to end the case, right? So it's like you giving up that chance and then happening to do the same thing again later for a motion for summary judgment. Also, summary judgments after discovery, where you get all the evidence and you still say, well, even after now, there's still not enough evidence to prosecute this case. It's still BS. And the standard's more or less the same too. If everything is true, then you still don't have a case. So it just doesn't make sense as a practitioner to give up one of those bites at the apple to get the case thrown out extremely early. And that's what Brown essentially did. He gave up this opportunity to get the case thrown out on the merits before having to go through these expensive depositions and discovery phase. It just does not make sense.
No, the deposition is going to take forever, because they're going to, if they haven't done so already, they're going to have to actually watch the videos. Both sides are going to have to watch the videos. So I don't know how many of the videos they've actually watched or what level of detail. But in order to actually do that deposition, both sides are actually going to have to watch the videos in full and review the transcripts of them in full. So I'd want to watch the videos in full. I'd want to get transcripts of the entire videos. So I have to pay someone to transcribe them for me, probably in a certified way, so that I can rely on them as evidence, that they're authentic transcripts. So I have to get someone to do that. So I'm going to have, for how many videos they have, how big is the binders that are going to contain all these things for the transcripts at a reasonable font size. Then I'm going to have to watch the videos while I'm reading them, and probably pausing and highlighting critical parts that I think either I want to ask questions about, or I think the other side wants to ask questions about, because I'm trying to anticipate the questions they're going to ask, which I probably won't be able to do perfectly, but I'll give it my best. Then I have to, so after watching them all and highlighting the parts that I have that I think that are going to be interesting, I have to actually write out all the questions for both sides. If I'm Brown in particular, I have to write out for both sides, because I have to figure out what questions Salts are going to ask, so that I can ask Katie, so we can figure out the right answer or how to phrase the answer correctly. And so I have to go through all that. I have to prep Katie, which will take forever.
That's going to
be forever, because we have to prep for every single video. We have to prep for every single question. We're going to have to do it more than once. All right. And then once we're done with all that, then we're actually going to have to fly over there and do the deposition, which is going to take multiple days, because then Salts' team is with their sets of transcripts and their sets of binders and their sets of videos going to go through the videos They may or may not go through all of them. They may do it in parts, but they're going to go ask the questions they want to ask. And then I have to be there to try to figure out how to respond and how to help my client respond to these questions in a way that's going to be accurate without slipping up, ideally, because if she makes a mistake, she can always be accused of lying or perjuring. So I have to try to prevent that from happening, and good fucking luck with that, as much stuff as there is.
And you've given them 4 declarations to also do it too.
Yeah.
You know what I'm saying?
So that deposition is going to cost, I don't even know. You're talking about 2 sets of lawyers' time who are going to have to at least watch all the videos. They might be able to agree on splitting the transcripts. That's the best, So maybe they can agree to splitting the transcript cost. But you're going to both have to watch it. You're both going to have to read the transcripts at a minimum. You're going to have to both prep together. The other side is absolutely for sure not going to tell you in advance what their highlighting looks like. That's privilege. That's trade secret information. It's like they're not going to share you their binder in advance. And then they're going to come with their binder and be like, well, we just have a few questions for you. Turn to page 1 of 1736. Here's my first question. Like, oh my God. Does anyone have some coffee?
It's insane. It's insane. And again, they could have avoided all this by putting in a motion to dismiss. But we'll see.
And I have to tell my client that you might be on your own at some point, because at some point in this exchange, I'm going to lose the will to live. So you have to make sure to protect yourself if I'm not paying attention at that moment.
Good question. Do you think if it's thrown out for jurisdiction and they refile in Minnesota, do you think she keeps Brown, or do you think she gets another attorney?
I don't think Brown wants to keep it.
You don't think Brown wants to keep it?
I'm not really feeling that Brown is necessary. I'm just going to take a flyer that Brown may not be necessarily the biggest fan of this case at this point. She might need a new victim.
Yeah.
All I have to say is, if she wants me, she's going to have to come up with a big check.
What would you keep the retainer at? This is not a $5,000 retainer. This is like a real retainer. We're talking about 20, maybe $25,000 retainer.
I'm talking about more than that, because I'm just anticipating, because I'm trying to make a reasonable anticipation about some of these attorneys' costs. And we're looking at, I'm going to need, can I get $100,000 retainer? That'd be helpful.
Because you got a lot going on. Because don't forget, everything you're talking about is for her deposition. You still have the depositions for the other side too, that you got to sit through, you got to prep for, you got to do the same whole process, right?
Yeah.
For Toddy, for James, so you got 2 people over there. You got to do the whole thing for too. So just imagine what Kirk just said about prepping KJ, and multiply that times 3, because you got to do it for James and you got to do it for, oh my God, it's going to be insane.
Yeah, and then of course I have to figure out whether or not I have any counterclaims if I'm Katie's side, which I don't even know what that would be. But I have to figure out if there are any counterclaims. I guess defamation maybe, but I don't know. I'm not. Do you see any counterclaims for Katie that are obvious?
I'm thinking. I'm up. Does she have any defamation claims? No, I don't think she really does. I don't know. I'm thinking. What could she do? She may have. I don't know. I'm thinking. What kind of claims could she have?
I could try some sort of bullshit restraint of trade thing.
I don't think she really has any counterclaims.
No.
Yeah. So this is all out of pocket. This is all out of pocket. Wow. Because but a counterclaim, you could even probably maybe go contingency. But I don't really see any
that's exactly why that's exactly the problem, and why I'm going to need a big ass pile of money up front, because there's no contingency. There's what contingency based on what? And now Toddy might have contingency. That's possible, because money might be flowing to Toddy, although I doubt there's enough. So, but there might, Toddy could theoretically have contingency with Salts. How could Brown even possibly have contingency with Katie? Because there's no money that's going to be flowing from Katie to Katie. There's nothing to have contingency for.
Yeah, there's no contingency.
So that means that I'm going to have to be paid on the hour, because there's no possible contingency. And just trying to make a reasonable calculation as to what my fees are going to be looking like. Because here's what I'm going to do with all this money, incidentally. I'm going to put it all in a bank account, that's going to be for just this case, because I can't keep it in an IOTA account. It's too much money. Course. So I'm going to keep it in a bank account. I'll keep it in Minnesota by law. I'll keep it in Minnesota in a bank account under trust for my client. take the big ass pile of money, $50,000, put it in the bank account, and then I'll start drawing from it as things are happening. So as I'm having to pay for fees and as I'm earning my pay and stuff like that, drawing from it. And yeah, I'm just trying to think, okay, how much money am I going to need? And I'm like, yeah, I'm going to need a big ass pile of money, because even charging like, I don't know, $200 an hour. I mean,
which is low, which is really low.
Which is low. So I'm talking, that's $2,500 a day, you know, especially for deposition, you know, so it's like, okay, so I'm going to run out of money rapidly. I'm going to need $100,000, Nate.
Yeah, the money's going to, but don't forget, you got co-counsel on both sides too, because they insult. You have co-counsel, then you got co-counsel here. Brown is not doing it alone. He's not watching, and look at all the videos and stuff that he's already looked at to send out these precipes, right? Looked at all these videos. He literally went through Salty's whole entire Twitter account and put in a filing. He had to read all that stuff before he's put it up there. So
yes,
yeah,
he probably read it. I mean, I would think so.
Yeah, before you file it.
So I'm going to need a big ass pile of money. I don't know that you have a big ass pile of money.
Not like, well, maybe KJ may be balling like that for all we know, right? She may be balling like that. I don't know, but I only thing I know is this is getting very expensive for some reason. But I don't understand why. This shouldn't be this expensive. This should be.
And it's not just my fees, but probably going to have to hire some paralegals. I might have to hire some co-counsel. I'm going to have to pay for transcriptions, court costs. I'm going to have to pay for people to do like certified things, like the certified transcriptions of the YouTube videos. Transcription services aren't exactly cheap. I have to get that done by someone who can certify to that. That's going to be expensive. So I'm going to have to hire my own personal stenographer for a while. Good times. Like, can you please transcribe this? This will be good. Just sit in a room and let me know when you're done. Stenographer for hire. And and the fees, not just to me, the fees to people I'm going to have to pay to develop things. And then there's going to be flights. There's going to be hotels. I'm having a nightmare just thinking about it.
It's
completely out of control.
It's insane. It's insane. It's insane.
On the plus side, though, that means that Katie will be judgment proof, because by the time she's done with the lawsuit, I will have taken all the money that she would have had to pay Toddy. So hey, you won't have to pay Toddy anything, because it will have all gone to me in the meantime.
But that's on the back end, though. That's one thing that you evaluate with your client, right? What can we get out this case? So obviously they're not trying to get Katie to pay the fine.
No, they're not trying to get the money.
Have that. So this is not a case about the money. Is this just a case about trying to get her to stop talking? Is that what this is about? Because if this is about stop talking, then I'm surprised they haven't made a phone call already. Like, all right, what do you guys really want from this, right? Because this is just getting too expensive. What do you guys want? Just don't talk about my clients anymore. Okay, done. I'm not talking about kids, you know.
What if we promise to never make another video about you, except maybe a video to say how sorry we are? Is it too late to apologize? Do we have to do a little Justin Timberlake thing? What's going on here?
No, but you don't though, right? If the best, what's the best interest of body for KJ to shut up and stop talking about them? Well, then reach out and say, hey, this is getting expensive for you. This is getting expensive for me. We just don't want you saying the shit you're saying anymore. You don't want to get sued.
That means I have to have the come to Jesus meeting with the client, Katie. Do you think I can have the come to Jesus meeting with Katie? Is that going to go well?
I think Katie's waiting for the other side to make that move. But I also think the other side. I think Toddy and them have deep enough pockets to go the long haul. I'm not sure Katie does though.
Oh yeah, no, this is a good question. Do lawyers still bill on the quarter hour? Hell no. We bill on the 10th of the hour. The 10th of the hour, man. 6-minute increments. 6-minute increments for life, man. Hell no.
Every 6 minutes.
And I'm gonna need $100,000 for that whiskey fund. Oh yeah, absolutely. Yeah.
Oh yeah. My lawyer charges 15-minute increments. But you can have a side deal.
That's some old school shit, man.
Yeah.
What lawyer charges 15-minute increments? I never heard such a thing.
A broke lawyer. But no. Usually it's 6-minute intervals, and if you ever work, the way it works is like for every 6 minutes, it's 0.1. So so, and you'll hear it's weird, but you'll hear like somebody say, that motion was a 0.5. That's 30 minutes. Or if somebody says, oh, that's a 1. that's a full hour, you know. So that's what you do. So every 6 minutes.
So if you're charging $400 an hour, that means for every 6 minutes you're charging $40.
Yeah. And it's quick. Don't forget that phone call. You know, those phone calls.
Oh yeah, no, every time I pick up the phone, I start my watch. It's 6 minutes for every portion thereof. So I'm going to be starting that watch, and yep.
But don't forget, you can also, you know, come to an agreement with your attorney about the whole about how you're going to bill, because some people, you know, if your attorney, you know, has a deal with you, you can say, I want to bill every 15 minutes. But then you'll have to come to the side agreement, like, okay, you know, I'm only going to bill you every 15 minutes and so forth and so forth. But generally, the floor is every 6 minutes.
Yeah, no, that's very, very common. Everyone bills in 6 minute increments.
Yeah,
I've never met a lawyer who doesn't bill in 6 minute increments, but okay.
No, well,
someone's doing it differently.
I do remember there was a law firm that my friend was working at. They had a big money client that they had a long-term relationship with. And their agreement was they would bill. I think it was like every 15 minutes or maybe every 10. It was something different than a 6 minute interval. But that was because they had that relationship. They handled this person's stuff all the time. Mm-hmm. So, you know, but they can come to a side deal like that. You know, but they couldn't come to a side deal. Well, I'm going to bill you every 3 minutes, because every 3 minutes would be a violation of the ethics rules. So you know, you can do it the opposite way.
So someone asked a good question. How's it work when you have a lawyer retainer? So there's two different kinds of retainers. So we should use our terms a little bit more carefully. There's sometimes what's called the classic retainer, which is very uncommon to have, but it's just a pile of money you give to a lawyer for no other reason than to be available when you need them. So that's what's called the classic retainer. So if we were doing a classic retainer and you want, so what would the situation be? It might be you want me as a criminal lawyer on
in-house counsel.
In-house counsel, right? So it's just money to keep me sitting in case you need me. So it's like, so the classic retainer is you're going to give me $10,000 a month merely so that I'm available for you to call. That's the classic retainer. Then there is the like case specific retainer, which is more common. So that is you come to me for a specific case rather than me just sitting around. So I say, okay, I need X amount of money because here's what. So you come to me and say, what do you need? And say, here's what I need. And say, if you want me to say boo, like filing it, it's going to be somewhere between $5,000 and $15,000. I know that just to start. 80, I'm saying I'm going to need a retainer of $100,000. So then what you do with that money is you put it into a bank account, as I said before. It's an individualized bank account. You have to put it into the state in which they live in. So that would have to be a Minnesota bank account. You put it as a trust account. So it's in trust for the client. So you take the money, whatever it is, $100,000, you put it in the bank account, and then you draw from it as expenses get done. So as you're going on along the case, you in your retention agreement, you say how you're going to bill them, notify them of billing. So maybe you're notifying them every month, maybe you're notifying whatever arrangement you have. Let's say it's once a month. So once a month, you send them a statement that says, here's what I've been billing you for. So you say fees, and here's like the time I spent, like whatever it would be, legal research. And every time you do something, you just mark it. So legal research, this much money that day, phone call, this much money, writing an email, this much money. Then you have like costs. So if I'm having to pay someone to do something like a certified transcription or paying a court fee or something, you list that off and be like, okay, here's how much it is. Here's how much we spent. Here's how much you have remaining. And so that's the mon retainer. Did I explain that correctly?
Yeah, that's I couldn't explain it any better myself. But and most of the time, I think most people when they pay a retainer, they don't understand that. Well, two things. Number one, you can't commingle funds also as an attorney. So the retainer has to be, the reason why it has to be in a separate account, because that's a huge ethical violation. And most attorneys who do get in trouble like Michael Avenatti. That was something that he did. He he commingled his funds, the retainer funds, with his own personal funds. He put it in his own personal bank account. So that was like a big issue. Yeah.
Yeah, and so someone said, I'm not sure if I can find the exact quote. Yeah, here it is. So all the money doesn't necessarily go to the lawyer. Yeah, I'm trying to project for all the fees. So how much I'm going to how much I need for my services, and then how much I need for the services I have to pay for. So like another way you say that is fees and costs. So like I'm responsible for what are the fees and what are the costs. Fees go to me, costs or anything else. So that can be court costs, that can cost for hiring someone else, it can be costs for whatever. But yeah, those fees are for fees and costs. So
most people fail to realize that every time you file something with the court, that there's a filing fee, right? There's a fee.
There is the initial $450 fee for the first filing. That's who.
No, you like you have filing fees for motions. Well, here you do.
That's true.
So like and it gets crazy, and you got to do three. It gets a little insane. But court costs can that's the way the court makes their money. Transcripts, for instance, when you got to get transcripts.
The transcript fees are brutal.
Yeah.
Brutal.
Oh yeah. In criminal court,
especially if you want like an expedited one, they'll charge you through the nose, which is probably incidentally exactly why they prohibit you from recording it. Because if you could record and produce your own transcripts, it's like, no, we're gonna keep those people in business, man. Yeah,
but I'm surprised they just don't. Well, I know New Jersey, they videotape everything now because it's like it's like data entry. You have somebody typing it all up, but you can just record it and just get it straight from. It's just it doesn't make.
So it's a good question. Like how does it work if you're called into court and you sign up to be appointed a lawyer for free? Financially speaking, how does it get paid? So this would come up almost exclusively in the criminal law context.
Yeah.
So how that works, it depends on the state. So it depends on different states. So some states have a public defender's office. Some states use private attorneys. Some states use a combination of both. But yeah, sometimes some states have they pay them like the prosecutor. So you have a prosecutor's office where they hire them at a salary, and you have the public defender's office where they're hired at a salary. So the state is just cutting them a check. So it's basically in that situation like a classic retainer. The state is paying this public defender, $80,000 or whatever the number is as a classic retainer. You are there for whatever we need, and we're going to need quite a lot of you, as it turns out. But yeah, so that's another situation. That can be supplemented, or it can be done exclusively by private attorneys. In which case, it's just a check that comes to the attorneys, and there's designated fees for that. But you have to sign up for that as an attorney, so you have to say that you're interested in that work. They're not just going to call a random attorney out of the blue. The only other situation that would come up with would be where you're being appointed. It would be rare, but you'd be appointed maybe by a court of appeal to argue a position as some sort of adjunct or something. The other one, which would be the other one where, that would be the other one. The other one is not only do I not want to be paid, I'd pay you. Is if the U.S. Supreme Court calls me. If the U.S. Supreme Court calls me, it's like, how would you like this case? It's like, where can I send you a check? Because it's just so prestigious that it's like, of course you do it. So yeah, I don't know if the Supreme Court offers any money, and I doubt any lawyer would take any. Because if they're calling you, it's like, we need you to come by. It's like, okay, yeah, I'm going to be doing that now.
Boom, that's top of the list, baby. Well, we were at hour 17 minutes in, and I got to prepare for another snow rainstorm tomorrow.
What is the snow news in New York?
Well, I think we had almost 20 inches right now, and now we got like another storm barreling down. So it's just like it's insane. It's insane. I'm hoping it doesn't hit before my kids go to school tomorrow, so my kids can go to school. I can go pick them up, and then I can be home before all hell breaks loose. Global warming is a thing, but not in the past couple of days.
Someone, Marzadote, said in the transcript from the hearing, the court said, "I'll rule the motion dismiss, and we'll go from there." And he thought this is why she made that statement, because like that's ostensibly why we were here. Yeah. It's like, shouldn't I be ruling on the motion to dismiss? Isn't that like the thing that we ostensibly are trying to do? So like, yeah, why as the court would I worry about anything else other than the motion to dismiss? How about I just go figure out the motion to dismiss issue and forget all the rest for a while? So it's like, what else would you expect? Of course.
Yeah, but the thing is that I think I know some people are saying that this judge wants to keep this case, but from what you're seeing now, if I was this judge, I would be praying that the motion, I'd be like, jurisdiction seems nice. Let this be somebody else's problem, because this prosecuting this case looks like it's going to be a problem. It's going to be a problem. Yeah. Do you think going through a trial? You think this is bad? Just imagine going through a trial. What about the witnesses? How many YouTubers have been named in this lawsuit already? And we're just at a motion to dismiss. Damn, Emily's been named twice in this damn thing.
I don't know that we're ever going to. I don't know that we're going to get to a trial. I think we'll get a dismissal one way or another, summary dismissal or something. I don't particularly see this going to a trial in the end.
if it goes to the trial, I think it would have been bad lawyering that forces it to a trial, because I do think we can get this kicked out before a trial. But
like, can I just roll on this and can we move on with our lives?
We will see. We'll see. Well,
with that being said, I'm gonna wish my guest well. As always, it has been our favorite guest. It is none other than Nate the lawyer, a lawyer from the great state of New York, the Empire State indeed, and is here with that Empire State of mind to help bring us in check and make sure that we get the law right. And I, as always, have been your friend Uncivil Law. If you've not done so already, please remember to hit the subscribe button. Why aren't you subscribed? Seriously, subscribe. It's free. It costs nothing. You get to hear more of my wit and charm, and you get my debonair looks. What's not to like? For 99 cents a month, you can become a member of the channel, and you can hit the like button. So all these things, I'm going to sign off. I hope all's well. Till later. Cheers and goodbye.